You've had a very interesting questions and answer sessions from Senator Specter, who asked you about cameras in the courtroom. I happen to agree with him and you that that would be a great educational opportunity for the American people. I know from experience that cameras can be placed unobtrusively in an appellate court, and no one really pays any attention to them, but it's a great opportunity for people to watch and learn, just as I hope they are watching and learning something about our judiciary and the Supreme Court as a result of these hearings. While I agree with you on that point, I confess to be troubled still about the exchange that you had with Senator Sessions over banning military recruiters at Harvard, and I expect we'll come back to that at a later point. But what I'd like to go back to is where I started in my opening statement, talking about the traditional concept of the role of a judge and an activist as I tried to define it, one that traditionalists who feels bound to a written constitution and written laws and precedent, as opposed to judges who believe that there is, whether it's their empathy, as the president's talked about it, or a living constitution which has no fixed meaning. That's what I mean by the activist role. In an earlier exchange with Senator Leahy, you stated that there are two ways to change the Constitution, obviously by Article 5, and you said secondly by court decision. And I want to ask you a little bit about that. And you cited Brown versus Board of Education as an example of a court decision that changed the Constitution, stating that the framers of the 14th Amendment believed it allowed segregation in schools. I believe, and I think a number of prominent legal scholars agree, that Brown did not change the Constitution. Rather, I believe Brown affirmed and restored the original meaning of the 14th Amendment by overturning the repugnant and unconstitutional separate but equal regime sanctioned by Plessy versus Ferguson. And so I support Brown on originalist grounds. I would just refer to you Senator Charles Sumner, a leading framer of the 14th Amendment, who said it's easy to see that the separate school founded on an odious discrimination and sometimes offered as an equivalent for the common school is an ill-disguised violation of the principle of equality. And between 1870 and 1875, both houses of the United States Congress voted repeatedly by significant margins, majorities, in favor of legislation premised on the theory that segregation of the public schools is unconstitutional. So in light of this history, I believe that Brown did not change the Constitution, but rather realign the interpretation of the 14th Amendment with the intentions of the framers of the 14th Amendment. And so on this, you and I may disagree. But let me
if I could, Senator Cornyn?
Sure.
I think I didn't say that Brown changed the Constitution. I think I said that Brown interpreted the Constitution in a different way than it had been interpreted theretofore. I do think it's hard to make the case that school desegregation was thought of as commanded by the 14th Amendment in 1868, and I think that there are a variety of other practices that similarly were countenanced in 1868 that are not now. Now, that doesn't mean that the Constitution has changed. In fact, the Constitution's Equal Protection Clause is a quite general provision. It speaks in broad terms. It lays down a general principle of equality. And in writing the provision that way, I think that the drafters of the Constitution knew exactly what they were doing. They didn't meant to constitutionalize all of their practices in 1868. They meant to set forth a principle of equality that would be applied over time to new situations and new conditions. And I think that's exactly what has occurred.
I appreciate your answer. What I'm trying to figure out is whether you and I agree or disagree about how the American people can change their Constitution. Do you think the court can change the Constitution, or do you agree with me that Article 5 has the sole means by which the Constitution can be modified. That is either through a constitutional amendment or a constitutional convention proposing constitutional amendments, which are later ratified by 3/4 of the states.
I think the Constitution is a timeless document setting forth certain timeless principles. It's the genius of the Constitution that not everything was set forth in specific terms, but that instead certain provisions were phrased in very general terms that enabled people, the courts over time to apply the principle to new conditions and to new circumstances. And I think that that's the continuing obligation of the court to do that, to ensure that the Constitution does apply appropriately and that the timeless principles set forth in the Constitution do apply appropriately for our posterity.
Do you believe in the idea of a living Constitution, that the Constitution itself has no fixed meaning?
You know, I think that I don't particularly think that the term is apt, and I especially don't like what people associate with it. I think people associate with it a kind of loosey-goosey style of interpretation in which anything goes, in which there are no constraints, in which judges can import their own personal views and preferences. And I most certainly do not agree with that. I think of the job of constitutional interpretation that the courts carry on as a highly constrained one, as constrained by text, by history, by precedent, and the principles embedded in that precedent. So the courts are limited to specifically legal sources. It's a highly constrained role, a circumscribed role. So to the extent that that term is used in such a way as to suggest that that's not the case, I don't agree with that. But I do think, as I just indicated, that the Constitution, and specifically not the entire Constitution, but the general provisions of the Constitution, that the genius of the drafters was to draft those so that they could be applied to new conditions, to new circumstances, to changes in the world.
So I'm clear. Do you agree or disagree that the Supreme Court of the United States can change the Constitution?
The Constitution does not change. The Constitution is unless by amendment. The Constitution is a document that does not change, that is timeless, and timeless in the principles that it embodies. But it, of course, is applied to new situations, to new facts, to new circumstances all the time. And in that process of being applied to new facts and new circumstances and new situations, development of our constitutional law does indeed occur.
And so do you agree that honoring the Constitution means respecting only the ability of the people to change it through constitutional amendment under Article 5?
Senator Cornyn, Article 5 gives the only way to actually amend the text of the Constitution. That is the only way to amend the text of the Constitution. But I also want to say again the sort of second half of this, that the text of the Constitution has to be applied to new circumstances, to new conditions, to new developments in the world, and that it's the job of the courts to do that.
And I can't disagree with what you just said, but to me, when you interpret the Constitution, how it applies to a given set of facts, that does not, to my way of thinking, imply that you're changing the Constitution, but rather interpreting and applying the Constitution to that set of facts. Do we agree?
I think that's right. The Constitution is the Constitution, but it is interpreted and it applies to new facts as they come up, new cases as they come up, new circumstances as they come up. So just to give a concrete example of this, and it goes.
Well, let's move on, because I think you and I agree so far, but let me challenge it a little bit more. As I've defined the term judicial activism, that is the belief that there is no such thing as a fixed meaning of the Constitution and laws, but rather judges possess some sort of power to create constitutional rights out of whole cloth. Do you believe that that kind of judicial activism, as I've tried to define it, is ever justified?
I think that judges are always constrained by the law. They're constrained by, sometimes the text speaks clearly, and then they're constrained by the text alone. Where the text doesn't speak clearly, they look to other sources of law. They look to original intent. They look to continuing history and traditions. They look to precedent and the principles embodied in those precedent. But they're always constrained by the law. It's law all the way down.
Let's change the topic slightly and talk a little bit about federalism. Millions of Americans believe that the federal government is simply out of control today because they were taught, as perhaps all of us were taught, that the federal government is one of enumerated powers and that all powers not delegated to the federal government are retained by the people and by the states. That's paraphrasing the 10th Amendment, of course. Under the framers' Constitution, the Supreme Court has an important role in limiting the reach of the Congress, which in my experience and my observation knows no limits to its own power. The only way Congress is going to be restrained is one of two ways. One is either the court is going to say you've gone too far, which occasionally they've done, and otherwise to have the people amend the Constitution, either through the constitutional amendment process or through the Constitutional Convention process, proposing amendments which are then ratified. But do you agree with me that Supreme Court cases in recent decades have largely eliminated the important role of the Supreme Court in checking the size and scope of the federal government?
Senator Cornyn, I guess I actually think that recent decades the court has suggested that there are some limits on the scope of the federal government. So if you go back to the earliest days, Chief Justice Marshall in Gibbons v. Ogden, that was the first case that, or at least the first important case that interpreted the scope of the Commerce Clause. And there Justice Marshall wrote a fairly expansive opinion talking about the interconnectedness of the United States and the need for the nation to function as a nation. Now, over time, the court imposed very significant limits on Congress's power. This was basically until about 1935, imposed very significant limits on Congress's power under the Commerce Clause. At that point, a switch took place, and the Supreme Court determined that the old jurisprudence really wasn't working, that the distinctions that the court had set up between direct and indirect effects on Congress wasn't working, that the distinction that the court had set up between manufacture and commerce wasn't working. And the court also, I think, realized, and this was really the great recognition of those New Deal years, was that deference to Congress was appropriate in this area.
How about today? You talked about some legal history that I'm vaguely familiar with, but today, let me give you an example. I'm not going to ask you to decide or tell us how you would decide the case, but for example, many Americans are concerned that the federal government in the recent health care legislation that was passed, that Congress has imposed an individual mandate on health coverage and imposed a penalty, a financial penalty, if you don't purchase government-approved health insurance. To my knowledge, that would represent an unprecedented reach of Congress's authority to legislate under the Interstate Commerce Clause, under the guise of regulating interstate commerce. But again, the 10th Amendment, which I think most people sort of popularly view as an expression of our federalist system, and the fact that the states and individuals retain power that's not been delegated to the federal government, has largely, in my opinion, been rendered a dead letter by Supreme Court decisions. Now, I grant you that the Rehnquist Court, the Lopez case, and others did begin to work a little bit around the edges, but if Congress can force people to who are sitting on their couch at home to purchase a product and penalize them if they don't purchase the government-approved product, it seems to me there is no limit to the federal government's authority, and we've come a long, long way from what our founders intended.
Well, I think the current state of the law is to grant broad deference to Congress in this area, to assume that Congress knows what's necessary in terms of the regulation of the country's economy, but to have some limits, and the limits are the ones that were set forth in the cases that you mentioned, the Lopez case and the Morrison case, which are where the activity that's being regulated is not itself economic in nature and is activity that's traditionally been regulated by the states. But to the extent that Congress regulates the channels of commerce, the instrumentalities of commerce, and also to the extent that Congress is regulating things that substantially affect interstate commerce, there the court has given Congress broad discretion.
And would you agree with me that if the Supreme Court of the United States is not going to constrain the power grabs of the federal government and constrain Congress in terms of its reach down to people's everyday lives, that there remain only two constitutional options available? One is either to pass a constitutional amendment for Congress to pass them and then to have that ratified by 3/4 of the states, or for a constitutional convention to be convened for purposes of proposing constitutional limits on Congress, which would then have to be ratified by 3/4 of the states. Do you agree with me that's the only other recourse of the people to a limitless reach of the federal government, assuming the Supreme Court won't do it?
Well, I do think that there are limits on Congress's commerce power. They're the limits that were set forth in Lopez and Morrison, and they're basically limits saying that Congress can't regulate under the Commerce Clause where the activity in question is non-economic in nature. I think that that's the limit that the court has set, but within that, you're quite right that Congress has broad authority under the Commerce Clause to act. And, you know, to the extent that you or anybody else thinks that Congress ought not to have that authority under the Commerce Clause to act, an amendment to the Commerce Clause would be a perfectly appropriate way of changing the situation. Under
Article 5 of the Constitution? In other words, the amendment process?
Yes.
Either through a constitutional amendment proposed by Congress or a constitutional convention proposed by the states.
Any part of the Constitution can be amended through Article 5.
I was pleased to hear you say that once decided by the Supreme Court, even by a 5-4 margin, that cases like Heller, McDonald, Citizens United are the law of the land and entitled to deference by succeeding courts, even if you may disagree with the outcome. Did I state that correctly?
Yes, surely. The entire idea of precedent is that you can think a decision is wrong. You can have decided it's differently if you had been on the court when that decision was made, and nonetheless, you are bound by that decision. That's if the doctrine of precedent enabled you to overturn every decision that you thought was wrong, it wouldn't be much of a doctrine.
I would just distinguish that from Congress. The rules, I guess, dating back to Parliament in England, that no Parliament could bind a succeeding Parliament. So this Congress can pass a law next Congress and essentially repeal a congressional act. That's entirely appropriate should Congress decide to do that, correct?
That's quite right, Senator Cornyn. It's a really fundamental difference between the legislative process and the judicial process. And the reason that the doctrine of precedent has developed, well, I suppose many reasons. One is just the incredible importance of stability in the system, but also just a notion of humility, that no judge should look at a case and say, oh, I would have decided it differently, I'm going to decide it differently, that a judge should view prior decisions with a great deal of humility and deference.
Well, it would be a strange system indeed if succeeding Supreme Courts. In other words, once you're confirmed to the Supreme Court and you're sitting there, it would be a strange situation if then the litigants could bring the same case back that was decided in McDonald or Heller, and because you happen to disagree with it, that you could change the meaning of the Constitution more or less at will. That would not be a good system of jurisprudence.
I do believe that, Senator Cornyn. I think when the court looks as though it's flipping around and changing sides just because the justices have changed, that's bad for the credibility of the institution, and it's bad for the system of law.
Let me talk a little bit more about guns. I kind of chuckled when I saw a notation in some of the records you got from the Clinton archives that you referred to some of the gun advocates as gunners, but I really didn't take that too seriously. I just thought it was kind of made me chuckle a little bit when I saw that.
Senator Cornyn, I've not seen that ever.
Okay, well maybe I'll show that to you sometime. But I just want to...
gunners is a kind of law school term of art.
Well, basketball, law school, whatever, yeah. It's but let me just ask you, isn't it true that in the McDonald case, as in the Heller case, that the court did not touch a number of permissible prohibitions on gun ownership and gun possession? For example, concealed weapons prohibitions on possession of firearms by felons or persons who are mentally ill, carrying guns in government buildings and the like. In other words, just by recognizing that an individual right to bear and keep arms, the Supreme Court didn't touch those prohibitions on gun ownership under a number of those circumstances. Wouldn't you agree?
Senator Cornyn, I've not yet had a chance to read the McDonald opinion that came out yesterday, but I know that in Heller, the court specifically says that nothing in the opinion is meant to suggest the unconstitutionality of a number of kinds of provisions, and I think the kinds of provisions listed in Heller are felon in possession laws, are laws regulating the possession of guns in certain sensitive places, and I think that there's one dealing with various commercial activities regarding guns. Right. But so the court said that really nothing in its opinion is meant to in any way cast doubt on the constitutionality of those long-standing laws.
I would just, and in McDonald versus Chicago, Justice Alito on page 39 and 40 of the slip opinion reiterated the same assurances that you just talked about in Heller that they would apply in the after the McDonald case was decided as well. Ms. Kagan, one of the things that you've heard a lot of us talk about is obviously you've had a very distinguished career, and we all congratulate you for the great honor of being nominated to the United States Supreme Court. But since you haven't been a judge, and no, that's not a disqualifier, we all know that, we don't have a judicial record, for example, like we had with Judge Sotomayor, by which to sort of see what her track record looked like when it came to deciding cases. And so we've been trying to get everything we can to understand where you're coming from, how you would perform your duties as a judge, and I congratulate you on your testimony here today. I think you've done a good job of explaining from the witness chair how you would decide cases. But one of the things that makes me a little skeptical sometimes is, for example, during the confirmation hearings of Judge Sotomayor, she said, we were talking about the right to keep and bear arms. She said, I understand how important the right to bear arms is to many, many Americans. In fact, one of my godchildren is a member of the NRA, and I have friends who hunt. I understand the individual right fully that the Supreme Court recognized in Heller. Let me read that last sentence again. She said, I understand the individual right that the Supreme Court recognized in Heller, close quote. But on Monday, in the dissenting opinion filed by Justice Sotomayor along with Justice Breyer and Ginsburg, that dissenting opinion said, quote, the framers did not write the Second Amendment in order to protect a private right of armed self-defense, close quote. I don't know how you reconcile those two statements, that there is an individual right, and then to conclude later on in the context of McDonald that the framers did not write the Second Amendment in order to protect a private right of armed self-defense. Justice Sotomayor went on and said, I can find nothing in the Second Amendment's text, history, or underlying rationale that would warrant characterizing it as fundamental insofar as it seeks to protect the keeping and bearing of arms for private self-defense purposes. Now, it is disconcerting, to say the least, where what appears to me, I think, and in fairness, does appear to be a direct contradiction of what Judge Sotomayor said in her confirmation hearings with what she has decided on the first opportunity to decide a case on that same subject. And so you understand why members of the committee are careful to understand not just the qualifications, background, experience, but the judicial philosophy and approach of the nominees, so that we can have some reasonable assurance that the way that the nominee testifies is not in deciding individual cases, but generally speaking, going to be honored and respected once they receive a lifetime appointment. Let me just ask you, do you believe that the Second Amendment guarantees a fundamental individual right to keep and bear arms for law-abiding Americans?
Senator Cornyn, I think that Heller is settled law, and Heller has decided that the Second Amendment confers such an individual right to keep and bear arms. And
do you believe the majority in McDonald, do you agree with that decision that the Second Amendment is fully applicable to the states, has full stare decisis effect, and is there any reason that you know of it would not be controlling?
There is no reason I know of that McDonald, as well as Heller, is settled law, entitled to all the weight that precedent usually gets.
Well, in the minute and 35 seconds we have remaining for this round, let me just take you back again to Citizens United. And I think a number, in the opening statements, you heard a number of differences of opinion on the part of this committee about the decision. But I would ask something you said that the court would look at in determining the constitutionality of restrictions on free political speech, that I think I heard you say that the court could look at the motives of the people advocating those restrictions. Did I understand that correctly?
I don't think so. I'm not sure what I said that you might have gleaned that from. I actually did write an article about this during my years as a law professor at the University of Chicago. It was not that the court should look to the motives of the legislature. It was really that First Amendment doctrine, quite a number of the rules of First Amendment doctrine were understood as reflecting a concern about governmental motive, but that the rules were set up so that the court never had to make that underlying inquiry about governmental motive.
Let me ask you one last question in the few seconds we have. Let's assuming that a majority party, let's say Democrats who enjoy a very large majority in both houses of the legislature, decide to suppress the speech of political supporters of the minority because they have the votes in order to do so, in effect trying to put a thumb on the balance, on the scales in terms of political speech. Do you think a court can look at those kinds of motives, seeking advantage, picking winners and losers in the course of restricting political speech?
Senator Cornyn, I think that the court does it, but not by looking directly at motive. One of the most important doctrines of the First Amendment is the near complete ban on viewpoint discrimination. That viewpoint discrimination is held to the highest constitutional standard. And that's because of a concern that the majority is attempting to suppress the speech of a minority. And the classic example is very much along the lines that you gave, is a legislature saying there will be no speech by Republicans, or there will be no speech by Democrats. And the way that the court would view that is that that's a classic example of viewpoint discrimination and is pretty much presumptively prohibited.
Thank you. Senator Durbin.